I know.
Mr. Curhan? Good morning.
Good morning. May it please the Court, Dana Curhan for Rui Novo. I'd like to focus first on the issue of so-called prior consistent statements that were admitted. The judge in this case admitted a prior consistent, under the doctrine of prior consistent statements, a handwritten statement that Melissa, the mother in this case, gave to a criminal defense attorney who had been hired by the family to assist her in this case. The judge's position was that because the defense had focused on a claim of recent contrivance, that this statement was admissible to rebut that claim.
Could you, in doing this, could you run through the chronology of statements that were made here by her?
Well, yes. I think there were two statements in early April.
All right, she's at the hospital. The baby has died.
Right.
She's questioned there.
Right. She makes some statements to the doctor. She makes some statements to the police. A couple of days later, she makes more statements to the police.
But the essence of the first statement was, I was giving him a bath when I noticed that he was injured.
And,
right?
and in all of those statements, she puts herself in the bathroom with the child.
Right. And so she says that at the hospital, and then she's interviewed twice by police officers. Is that correct?
That's right.
In those interviews, does she also say the same, putting herself as the person who was bathing the child when this injury occurred? Or?
Yes, she does. She then goes to a very confident...
So she said this 3 times. Now, after the third time, I take it the defendant was then arrested. Her boyfriend was arrested at this point.
Yes, I believe that's the case. I think he was arrested, but she also was started to understand that she was in some trouble. Her family hired a lawyer.
Well, on April 3rd, as I remember, which would have been the third time, they were taken separately. One was taken by the local police, one by the state police, and questioned.
That's right.
And at the end of that questioning, wasn't Mr. Novo arrested?
Yes.
All right. So then criminal counsel is retained by Melissa's family for Melissa?
That's right.
And then she writes out this statement to her lawyer telling a very different story?
That's right.
Okay. So that's the statement we're talking about.
That's the statement.
Which was admitted after she testified on direct examination and cross-examination at trial.
That's right. And she made a number of statements once she started cooperating, and her statements were to the effect of, it's all Mr. Novo who did this, and she really minimized her role and put him in the bathroom with her and really implicated him. Most of those statements took place in 2004. I think it was first of all, I don't think the defense was recent contrivance. I think it was long-standing contrivance that took place once she realized that she was in trouble and then consulted with a lawyer. So I don't think that it was necessarily recent contrivance, and I don't think...
Was that how it was phrased at trial? That it was long-standing contrivance, or was it recent contrivance, the way the defense attorney argued it at trial?
Well, I think defense attorney argued that it was long-standing contrivance, that this was part
and parcel of her attempt to shift the blame to him.
That's right. And it only took place once she had a lawyer. And, I think there are, first of all, recent contrivance or prior consistent statements are admissible if a witness made the statement before she had an incentive to fabricate her statement. Clearly, she had an incentive to fabricate her statement. She had a lawyer who asked her to make a statement or write down everything that happened, but of course, I think at that point she understands that she better get herself out of it. She's in a lot of trouble. And the posture of the case was either she did it or he did it. And I think once she talked to a lawyer, she understood that her only way out of this was to make a statement implicating him.
Mr. Curhan, in these infant death cases, we not infrequently see that there were more than one adult who was in close proximity to the child before the child died. It seemed to me that what was a little unusual here is that there was quite compelling evidence of how she had physically beaten quite brutally these children herself.
That's right.
Did defense counsel link that? In other words, in addition to the recent contrivance versus long-standing contrivance, did defense counsel argue that in the context of this case, where there was evidence that she had been physically abusive herself to the child who died?
Well, I mean, that's the problem. That's actually the ineffective assistance of counsel claim. That evidence was there, and it was in the grand jury, but it was never brought out.
None of it was brought out?
None of it was brought out.
Were the witnesses available?
The witness, I assume the witnesses were available. There's nothing to indicate that they weren't. Let me just make one more point on the prior consistent statement. There is, in that prior consistent statement, so-called prior consistent statement, she does say some things that are very self-serving and obviously false. She says that she asked Joshua if he was okay, and he said yes, he was. Now, obviously,
This is in the statement that she prepared for her lawyer.
That was in the statement. That was obviously false, and she so indicated at trial. I think that one of the things we focus on...
Is that because Joshua at that point was incapable of speech?
That's right. She testified at trial that his eyes rolled back in his head and he was not responding. Mm-hmm. So one of the things that we have to focus on in prior consistent statements is the reliability, and I think if she's making false statements in that, very significant false statements in that so-called prior consistent statement, it should not have come in.
Did she waive the privilege here?
I'm sorry?
Did she waive the privilege, her attorney-client privilege, implicitly?
Well, I assume she did.
Was there any attempt made to call the attorney to have him testify as to what was said?
No, I think this came up sort of suddenly in the middle of trial, and no, there wasn't.
So at trial, she testifies consistent to a certain extent with this statement, saying that she was not in the bathroom, she wasn't the one who gave the baby the bath, right?
That's right.
And she was cross-examined, saying this is inconsistent with what you told the hospital, inconsistent with what you told the police on several occasions. That strikes me as appropriate, of course. And there would be no basis to then, for the Commonwealth then to offer her statement made after those statements, correct?
I think at the most...
Her so-called prior consistent statement, because they would not have been, well, in any event, it wouldn't have been proper, right?
I think so, but if you would allow that earlier statement in, I think maybe you allow the fact that the statement was made and that at that point she identified Rui Novo as the person who did it, but not the details.
Well, the examination, as I take it from the briefs, and I don't have the transcript yet, but the examination, as I understand it, went further than just saying, didn't you make these prior inconsistent statements right at about the time of the death, also questioned whether she, what statements she made in 2004 to the district attorney, or subsequently made when she was negotiating a deal with the district attorney's office. Is that right?
That's
now,
right.
Certainly, at that point, you are, at least there's a suggestion that she changed her story when she was negotiating with the district attorney's office. So I assume that a prior consistent statement prepared sometime before that might be admissible.
You know, I think if she went to the newspapers and made a statement, or she made a statement to a friend, or she said something in circumstances where she did not have a motive to fabricate it, I'd say that would be admissible. Mm-hmm. And maybe even the fact that she made a statement to her lawyer that was in some ways consistent with what her trial testimony is, that may be admissible. I think the way it came in, reading it to the jury with all of the details, I think that's a real problem. Mm-hmm. And especially where there's a serious problem as to reliability, there were no limiting instructions or instructions on how that should be used. And there's clearly a motive to fabricate. I think that's what the problem is.
The Commonwealth keeps talking about it as recent contrivance, namely various statements, as Justice Cordy said, deal with the Commonwealth to testify in exchange for, reduced penalties or promises of whatever it is, and then she testifies. That's classic recent contrivance. Your argument is, long before that, she began to change her statements because she knew she was in trouble. Was that argument made?
I think that argument was made at the, I don't think it was made as clearly as it could have been, but I think there was, trial counsel clearly knew that there was this earlier statement. And he also knew the circumstances.
And how did he know there was this earlier statement?
I think it had been disclosed in discovery.
If it had been disclosed in discovery, isn't that an implicit waiver of the attorney-client privilege?
May very well be.
In which case, why didn't defense counsel interview the lawyer?
That's a good question. That may very well be ineffective assistance of counsel on his part for not doing that. I think probably...
Maybe he doesn't want to hear what the lawyer said. Maybe the lawyer will say, most likely the lawyer will say, I just told her to write down the truth.
That's fine.
What is the lawyer going to say?
It could be. And I don't think he was, I don't think he would stand to gain anything significant by doing that, in that I don't think he was contesting that this statement was actually made and was made to, to defense counsel. I mean, I don't think there was a lot for him to gain by questioning her counsel. And maybe he should have, I don't know. But
well, if that becomes important, that's all for development, assuming the conviction's affirmed on a motion for new trial for ineffective assistance.
Possibly. I mean, I could...
testimony and so forth. We don't, strategies may have been operative here and so on.
I can see a strategy in not doing that. Now,
too.
on the other hand, I can't see a strategy for not calling the 3 witnesses who testified before the grand jury and who very clearly talked about a pattern of child abuse by Melissa.
Serious child abuse.
Very serious.
Now, this was the grand jury that indicted the defendant as well?
That's right.
And indicted her. So
What about the, I'm sorry.
they were hearing evidence as to both of them.
I think they were probably hearing evidence as to both. But
I mean, what if these witnesses came in and said, oh, yeah, she, beat up the kid, so forth. He did, too. Not so good, is it?
well, they didn't. That's the problem.
What about the reasons that the Commonwealth gave in its brief why these witnesses were not called? I think the Commonwealth said that one witness wasn't credible because there were many inconsistencies in his grand jury testimony itself. That was Michael Santos. They said the same thing about Dodie Strawn, and then the other one, Tracy Lopes, the former roommate. The Commonwealth argued that she had testified at the grand jury that Melissa sometimes hit Christopher. She said it was abusive and that Melissa was very protective of Joshua and never hit him. So that doesn't sound like a very good witness.
Well, I mean, first of all, I don't agree. Reading the grand jury testimony as a whole, I don't agree that these witnesses that their testimony was inconsistent in any significant way. I don't agree that anything that they said in front of the grand jury in any way inculpated the defendant.
No, but if the testimony, I mean, there are some parents who don't like one child and like the other one. And if one witness says she hit Josh, but never, she hit the other child, but never hit this baby.
Do we know if the defense lawyer interviewed these witnesses?
We don't know.
Okay.
But
isn't this also a topic, assuming the conviction is affirmed, that would be developed on a motion for new trial? I mean, what if he had interviewed these people and found out all kinds of stuff that would get him in serious trouble?
Well,
here's
the problem. The defense clearly is Mr. Novo did not do it. Melissa did it.
Yeah.
That was his defense. It was not a theoretical defense. That was his defense.
Yeah, pretty good defense.
And it was a pretty good defense. But the missing piece was that there was no evidence introduced that Melissa ever abused her children.
Well, I know it, but what I'm suggesting is that these witnesses may have in the grand jury given something that looks favorable to the defendant, but if this defense lawyer had interviewed them, which we don't know, maybe he had discovered some stuff that would have seriously harmed the defendant.
I think what you have to do, I mean, I think even if there is something that is harmful, I think you have to put these witnesses on the stand. You have no other way of proving this crucial element of
your point
case.
is he put nothing on the stand.
He put nothing on the
So
stand.
he couldn't, did he argue to the jury that she had abused her children?
Well, he couldn't because there was no evidence of it.
I thought there was some evidence. I thought one of the Commonwealth's witnesses, was it Melissa's sister or mother, that testified and was cross-examined on the question of whether Melissa ever struck the children?
The sister said he would slap
He or she?
Christopher. She
Yeah.
would slap Christopher on the mouth and on the behind when he misbehaved, but never touched Joshua.
Okay.
So there's no evidence of any serious abuse. There's no evidence of any abuse of Joshua. The only evidence of that were these three witnesses who testified in front of the grand jury.
But you
And-
can't say three witnesses because one witness was consistent with Melissa's sister who said she never touched Joshua.
That's right. One was, but she testified to some pretty serious abuse of Christopher. And I think that would have been helpful. You could have made a judgment call on her, but I think on balance you call her. Now, you know, what is significant is that Christopher testified, Melissa testified, Melissa's parents testified. None of them ever testified that prior to this weekend that the defendant had done anything toward either of the children. I don't think you're taking much, if any, risk by putting these witnesses on the witness stand, but if there is some risk, I think it's a risk that you absolutely have to take. Because the only thing he had in his closing statement was, well, Melissa came in there and told you 6 times that she was in the bath with Joshua. Now she comes in and says it was Rui. Well, yes, she lied, but I don't think that gets you there. I think what gets you there is this woman capable of doing it? Does she have a pattern of child abuse? And evidence that she is hitting her kids, that she's kicking her kids. On one occasion, Christopher was down on the ground and she's kicking him. On one occasion, she hits Joshua in the face and gives him a welt. I mean, this is the type of evidence that would have absolutely established this defense. And whatever these witnesses may have said if you had interviewed them out of court, when they went before the grand jury and they were questioned by the Commonwealth, not by the defense, the Commonwealth presumably is trying to get out evidence, the most favorable evidence it can get against the defendant.
So I take it goes something like this. The worst that can happen is that the witness says she was a wonderful mother and he always beat. Then you say, do you remember going before the grand jury? Yes. Here's all your testimony that she was an abusive mother. Yes. And you never said before the grand jury that he was abusive. Yes. So that's the worst case for the defendants.
Right, and I think Dodie Strawn, testified that he was very good with the kids. And you know, then you have Christopher and you have Melissa who...
No, I understand. What I'm saying is that to take your point, that the very worst that can happen is that the witness absolutely changes. The least worst is, yes, she was abusive, but he was also abusive, and then you cross-examine and say, but you never told the grand jury that, and this is an investigation of to who had abused these children.
Absolutely.
So it's hard to see how much worse it can get.
Of course, we've got to look at the questions these witnesses were asked in the grand jury. The questions. Because the responses are tailored to those questions. Did the questions naturally lead to a response that would say she was abusive too? You follow me?
That he would... I mean, I don't think they were avoiding questions that would have... I'm not sure...
Well, if the witness is asked, did you see Melissa abuse the children, that's one thing. If the question is, did you see Mr. Novo abuse the children, that's a different thing. The answer to that is just about Mr. Novo. It's not about her. So the questions frame the answers in front of the grand jury, do they not?
I think they do, but I think the questions were broad enough to elicit any evidence that either of them would have...
Okay, so we got to look at the questions. Keeping in mind, I'm sure witnesses are instructed when they go in there to answer the question that's asked and not to volunteer information and go off on tangents, you know, the usual stuff that pertains to trial, so on. You with me?
I'm with you.
Okay. We've got to look at it.
Is the grand jury testimony, by the way, part of the record in this case?
Yes.
I believe it is, yes.
Believe?
If it is. If it isn't, if you don't
Well,
have
this
the
is a
grand jury
33E
minutes.
review anyway, isn't it?
I'm sorry?
This is a 33E review
Yes, it
anyway.
is.
So the
But we
question
normally
is it
don't look at-
already up here?
We don't look at grand jury in that testimony ordinarily.
If there's any,
But if we'll look at it. We'll get
I
it.
think it's a reference in the briefs. If you don't have them, I can make sure I provide them. Unless there are any further questions, I'll leave the remaining points to the brief.
Thank you,
Thank you.
Mr.
Thank you.
Cohan. Ms. Blackman?
May it please the Court, Tara Blackman for the Commonwealth. The first issue I'll address is that of prior consistent statement. The Commonwealth argues that, in fact, Melissa's handwritten statement to her attorney was admissible because there was a claim of recent contrivance by defense trial counsel at the trial. Defense counsel's entire strategy, or part of defense counsel's strategy, was showing that in Melissa's first two statements to the police, April 1st, 2003 and April 3rd, 2003, she stated that she was giving Joshua the bath. However, after she was arrested and started entering into plea negotiations with the Commonwealth in 2004, in her latter three statements, all of a sudden, it was Rui Novo giving Joshua the bath. This type
I thought that she had, that there was conflicting evidence in the statement to her attorney. Am I wrong?
There was, in her statement to her attorney, she stated that the defendant was the one giving the baby the bath. So that supported.
You go back to that point, and you look to see whether there's some reason why this may be a contrivance. This is not a recent contrivance, correct?
Well, it's a recent contrivance starting from her 2004 statements onward. So it's not a recent contrivance in the sense that she breaks up a brand new story at time of trial, although that was part of defense counsel's argument too, that she kept conforming her story from the time of March 2004 to the time of trial to fit the type of story that would get her the best deal with the Commonwealth.
So is your argument that defense counsel at trial argued that the recent contrivance stemmed from the date of her cooperation with the police, and that now the argument is being altered somewhat to being that the recent contrivance stemmed much earlier?
Precisely, yes.
And when we look at the record, there's nothing, as Mr. Cohan suggested, that said that it predates that? The classic situation is witness says one thing, Commonwealth comes to witness and says, we're going to indict you, but if you testify for the Commonwealth, we won't indict you. That's a very crude, or we'll recommend a lesser sanction. Here, at least on appeal, the defense claim is no, long before that. That's not recent contrivance. She really started manipulating, and that was part of her attempt to protect herself, not a contrivance as such. And you're saying that there's no reference to that? If we look at the claims that the objection at trial?
The objection to trial, no, there is no reference to that. The objection to trial, defense counsel objected on the grounds that, look, this is, I don't think this meets the standard for prior consistent statement. It's not handwritten. It's not signed. It's a handwritten statement. And the judge overruled that objection on the basis that it was a prior consistent statement and that it was being used to rebut.
We have to keep in mind in looking at this particular issue that judges have a great deal of discretion, correct?
Yes, Your Honor.
And determining whether it meets the standards, doesn't meet the standards, and by and large, if they exercise, in this case, his discretion, it's almost unassailable unless it's just completely wrong.
And I think that's correct, Your Honor. And I think that we should look at one of the cases that defense counsel cites in his brief for support is a mass appeals court case, and that's Commonwealth versus Cruz. And in that case, the Commonwealth argued on appeal, look, this was also admissible as a prior consistent statement. And the SJC, one of the grounds for saying wasn't admissible, one of the things that they looked at is that the trial judge, didn't even have the opportunity to evaluate the appropriateness of this as a prior consistent statement, because this wasn't the ground that it was admitted on. But that's in very clear distinction to this case, where in fact the judge knew the criterion that he was evaluating this statement as to whether it should come in as a prior and consistent statement as. He had heard the testimony. He had heard the trial counsel's opening. He had just seen the cross-examination of Melissa, where defense counsel tried to impeach Melissa with her 5 statements made prior to trial, and was able to evaluate, look, does this meet the criterion for coming in as a prior consistent statement? And the judge found that it did. And I would argue that that was an appropriate decision on the judge's part. He had just seen Melissa impeached with claims that she had made up this statement in order to get 5 years of probation, in order to make a deal with the Commonwealth. And he was able to evaluate it and say, look, this should come in as a prior consistent statement.
But the key to a prior consistent statement, as the Chief Justice was asking, is that it was made before there was an incentive to fabricate. And it strikes me that after she's interviewed 3 times, twice by the police, her boyfriend is arrested, she hires a criminal defense lawyer, that she understands that there's a good reason to distance herself from this death, this child.
She may understand that there's a good reason to distance herself. So there could be a potential motive at that time. But I don't think that from the transcript of the trial that was what, in fact, trial counsel was arguing. I believe that trial counsel's main strategy was to argue that she was making up the story after she began really making up an essential part of this story, that Rui Novo was giving Joshua the bath when she was meeting with the Commonwealth in order to enter into plea negotiations. And I think that's the motive that we're looking at in this case. That's the incentive. Because, in fact, defense counsel's entire defense hinged upon the jury believing that what Melissa said in her first 2 statements, at least the part about Rui Novo giving Joshua the bath, was true.
Again, you may well be correct, and then we flip to ineffective assistance of counsel. But I need to understand why the statement was made to the attorney doesn't suggest, or put it in the positive, would lead one to conclude that she had no incentive to fabricate at that time.
I think that it would. I think that it would suggest that she had no incentive to fabricate.
She's gone to see a defense attorney?
Oh, well, she knows that there's a problem, but I don't think she has the incentive to fabricate because she hasn't been arrested yet. The incentive to fabricate, I think that the defense counsel at trial was concentrating on, is that she had been arrested.
No, I understand what trial counsel is, and I'm just saying, objectively, leave aside what trial counsel did or didn't do. You may well be correct, and so it's not preserved, and then we hear on some other basis. She makes statements that are, not just marginally inconsistent, they are flatly inconsistent at the critical moment. And as defense counsel points out, they are false, even within her own, because she says, I didn't notice anything wrong, or whatever it was. Why should we conclude from that at that point this can't be viewed under whether or not she had an incentive to fabricate that statement to the defense attorney?
Well, there may have been some incentive at that point to fabricate the testimony, but that wasn't the claim that this prior consistent was brought into rebut.
So there may have been an incentive to fabricate.
There may have been an incentive to fabricate at that point, but that wasn't what this prior consistent statement was brought into rebut. And based on the implications of defense counsel during his opening, during his cross-examination, and finally at the end in his closing, this was properly brought into rebut the contention that trial counsel was trying to make.
And if there was an incentive to fabricate, wasn't it ineffective of counsel not to say to the judge, look, judge, you've got to have a prior consistent statement which, indicates, which will rebut that there was no incentive to fabricate. And as I understand it, there's probably a good reason for her to fabricate at that stage.
There is a possibility that defense counsel should have said that, should have done that. And if that is the case, then that would be looked at under the ineffective assistance of counsel standard, which would be substantial likelihood of a miscarriage of justice. And even so, even if we look at that, this admittance of this statement under that standard, the Commonwealth would argue that the omission of this statement could not have created a substantial likelihood of a miscarriage of justice in this case for several reasons. One, because it was merely cumulative of her trial testimony. It did add anything of it in regard to additional facts, which is in distinction to say the additional facts in Commonwealth versus Cruz, that the statement came in. It added additional facts. Here, no additional facts were added. Also, the jury would have been able to assess the credibility of the statement, understanding that it was brought in.
Isn't the issue in this case whether he did it or she did it? I mean, that's the defense, correct?
Yes, yes.
And here, essentially what the Commonwealth's position is you can believe her testimony because she had no reason to fabricate this at the time, and look what she told her attorney. It's hard for me to see why that's cumulative.
Well, it's cumulative to the extent that it was very much what she said in her trial testimony.
Well, of course, that's the point. That's why, and that would help the jury.
Well, but the jury would have also been able to assess the credibility, the value of that statement, because they had just seen this witness impeached with 5 statements, had known that her testimony did change from even her latter.
I take it the Commonwealth, I haven't read the closing argument, but I take it that the Commonwealth said, look, we know she was telling the truth at trial because she told the truth how many months beforehand, weeks beforehand to the attorney, correct?
Well, I think the
Did the Commonwealth make that? Did the Commonwealth make that argument?
Actually, the only time that this, and I think that's also important, Your Honor, the only time that this statement was brought out was during redirect examination to rebut the contention. It wasn't brought out in the prosecutor's closing argument. This wasn't a repeated attention, repeated focus to this handwritten statement. It was only brought out in redirect to rebut the trial counsel's repeated contentions, repeated implications during cross-examination that here Melissa was after, in 2004, all of a sudden making up these new statements that Novo was the one giving the baby the bath. And
the fact that it only came out in redirect is not surprising, since that's the only time it could come out. The question is, as you suggest, how was it used, perhaps in closing argument or otherwise?
And it wasn't used in closing argument.
There's no reference to it in the closing
I
argument?
don't believe so.
What about these 3 witnesses?
Yes, the ineffective assistance of counsel claim. As the Commonwealth has pointed out in its brief, first of all, the first thing to concentrate on is what was brought out at trial. And what was brought out at trial? Melissa's own sister, Michelle, testified that Melissa hit Christopher. This came out at trial. The jury
she
knew.
also testified that she didn't hit Joshua.
Exactly. Same as Tracy Lopes testified at grand jury testimony.
Was there anybody at the grand jury who testified that the mother did hit the child who died?
Yes. That was Michael Santos. And the problem here is that Michael Santos's grand jury testimony was completely inconsistent. Everything in Michael Santos' testimony.
For example,
1 minute he was testifying, yes, she hit the children, I was really, really concerned. Next minute he's saying, I wasn't concerned until she moved in with the defendant because I knew what was happening with them. Another inconsistency.
We will read the grand jury testimony because obviously defense counsel says, I don't think it's that inconsistent, and and it may well be inconsistent in some aspects and maybe in total
Of
aspect.
course, we don't know what defense counsel did outside of the grand jury with these witnesses. He may very well have interviewed them. He may have found that Michael Santos had a criminal record a mile long with which he'd get impeached, perhaps even for child abuse, et cetera, et cetera, et cetera. So even if there's a glimmer of success on this issue for the defendant, ineffective assistance would have to go back for an evidentiary hearing, would
I
it
think
not?
that's true, Your Honor. Yes, I think that's true. Because we don't know exactly what Michael Santos would have said. But can tell from his grand jury testimony that it could have been potentially dangerous for defense counsel to put him on.
Well, sure, because in the grand jury, he's testifying without any risk of cross-examination. He gets into the courtroom, and he gets cremated by the prosecutor.
Exactly.
What is in his grand jury apart from the inconsistencies, what is in his grand jury testimony that, I forget the words that you used just before Justice Glaney asked you the question, about why you could tell from the grand jury testimony, apart from inconsistency, why defense counsel might not have wanted to call him as a witness?
Well, he might not have wanted to call him as a witness because he could have potentially testified. Look, I didn't see, I wasn't worried about the kids until.
No, I thought you said he said something in the grand jury. Maybe I misunderstood you.
Something other than inconsistencies.
Oh, yes, he did. He did say something in the grand jury testimony. He said that there was some testimony to the effect that the defendant was jealous of him. That there was also some testimony to the effect that
the defendant was.
He wasn't worried about the children until she moved. Melissa moved in with Rui Novo, and I think that all of that goes to look. Maybe this would have bolstered, and this would have potentially come out on cross-examination, that Rui Novo was violent toward the children. That the reason why he wasn't so worried until Melissa and the children moved in with Rui Novo was because Rui Novo was jealous of.
I understand that. That's the hypothetical I gave to Mr. Cullen. The worst, in theory, is that each witness gets up and says, inconsistent, not having said this at the grand jury or inconsistent with it, she never abused the children, he always abused the children. Defense counsel's claim here is the jury didn't know that she abused or had no evidence that there was sworn testimony that she had abused the child who died, correct?
Well, actually, there was, no, not the child who died. No, there was no sworn testimony that she had abused the child who died. But the thing is it potentially would have been more dangerous. Melissa was clearly not a perfect parent. The jury knew this. I mean, the jury was made aware of this fact. Whether or not she was the one beating the children or she was watching Rui Novo do it, she was clearly not the perfect parent. So I think it may have been more harmful to the defendant for the jury to hear Melissa was really violent to the kids and Rui Novo was really violent to the kids. Because it would have been harmful for the jury to hear, additionally harmful, Rui Novo was really violent toward the children. The issue was not who hit them. The issue at trial was who was giving Joshua the bath. And even if Melissa hit Joshua now and then, even if testimony to that effect came out, it really wouldn't have helped the defendant all that much because the issue was who was giving Joshua the bath. The jury knew that Melissa was not the perfect parent.
Can I ask you this with respect to the prior consistent statement? Did the judge ever instruct the jury as to the appropriate use of that kind of material? Because it's a very limited use.
Correct, Your Honor. No, there was no limiting instruction, and there was actually no request for a limiting instruction by counsel. And this court has found that, in fact, that's not reversible error if the counsel does not request a limiting instruction. Now, I would argue that if the court was to evaluate that, to say, look, we find that this statement was questionably inadmissible, and the question is whether it was a prejudicial error. I would suggest that maybe a limiting instruction would have mitigated its effect, and therefore, if anything, it should be looked at under a substantial likelihood of miscarriage of justice standard that we're looking at here, because for counsel failing to ask for such an instruction. But, however, the Commonwealth argues that there was no error in it coming in, and that the failure to give an instruction, the jury would have understood its value, especially considering that it came in on redirect after Melissa had just been cross-examined by trial counsel on her statements that she made after entering into plea negotiations. So I would suggest that any harm was mitigated by that.
Thank you.
Oh, you're welcome. With regard, I will address now the last three arguments that defense counsel makes.
You got 27 seconds.
Oh, okay. Well, then I guess I will rest on my brief. So for the foregoing reasons, I rest on my brief for the remainder, and for the foregoing reasons, the defendant's conviction should be affirmed.
Thank you,
Thank
Ms.
you.
Blackman.